we are prepared to continue. We have 68 participants. That's a great number. And we have decided that I would continue speaking in English in order to cater for all international guests that we have in this seminar. So the next step of the program or the session is called Studies into Sami Traditional Culture, Traditional Knowledge and Intellectual Property Rights, the next step. And the idea here is to go more into substance. So we have heard a political level statement, both from the Sami and also from the ministry, and the wishes for improved cooperation on the Nordic level. Then we heard some technical level work being done between the Sami parliaments, and also the idea of a network for traditional knowledge that we have had in Finland, and maybe could be a model for the Nordic level as well. So now we go into the more substantive issues and issues relating to IP. So please, Tuomas Mattila, you have now the floor. I remind all of you that there is a portal for the material, so all the presentations are available there, except for the ones who did not have slides. But we will try to provide short English summaries of these speeches that have been already submitted. So please, Tuomas, you have the floor.
Yes, thank you very much, Anna. I hope you can hear me. So good morning, everyone. My name is Tuomas Mattila. I'm a doctorate student in the University of Helsinki in the Faculty of Law. And firstly, I would like to thank the organizers for this invitation and opportunity to speak here today. It is an honor to be a part of this important process. My work regarding indigenous cultures has mainly concerned how already existing intellectual property laws could be used to protect traditional cultural expressions. And in this brief presentation, I provide some insights to my work, a couple of practical examples and propositions. So firstly, since intellectual property rights are exclusive rights, in other words, a right holder can prevent others from doing something, the substance of the protection must be defined precisely. And for this reason, a broad definition such as culture or tradition cannot be protected by intellectual property. Instead, it is the definable expressions such as signs or symbols for which a protection can be sought. Therefore, there is no holistic model that would fit into every situation, but rather a piecemeal approach, trying to use what we already have. And the aim of these measures could be to prevent unauthorized, offensive, or misappropriating use of the TCEs. I make first two examples purely from a legal point of view, and then make some comments from the practical side. Firstly, Nordic copyright laws protect the classic works. In short, if after the death of the author, a copyrightable work is used publicly in a manner which violates cultural interests, the authorities may prohibit this action. For example, if a certain TCE, such as Sami dress, which has a particularly high cultural values, would be publicly misappropriated in such a way that is derogatory to those values and traditional norms that have been accumulated in it during the generations, it might be protected by this clause. This would practically mean that the authorities could prevent such a use. Now, legally speaking, there are further questions still unsolved. Firstly, could Sami dress be perceived for the purposes of this clause as a work in copyright sense? Is it original in copyright terms? Who is the author of the Sami dress, and could the Sami community as whole be considered a collective author of this work, even if individual historical persons, the first users and creators of the physical forms seen in Sami dresses, have likely passed away a long time ago? If yes, the copyright law would be applicable and the clause could be, at least in theory, used. Then it would require a case-by analysis whether the misappropriating use in question violates cultural values. It should be asked, what is the cultural value in it, and whose cultural values they are and what is the offense. I believe that in some cases there would be a good possibility to make a strong legal argument on behalf of this claim. And in my mind, it would be recommendable to ask an opinion of the Copyright Council in Finland regarding the Sami dress's nature as a work in copyright terms. If the response would be affirmative, we would know proactively that whenever the need might arise, the protection of classic works is an available remedy. This would also establish a legal warning, let's say a signpost, indicating to any commercial or artistic user of a Sami dress that is being protected by this clause, and the user should take this into account in their desired use of the dress. Secondly, trademarks may be used to protect traditional culture. A good example is Sami Duoji and Sami Made trademarks, which can be used to guarantee certain quality, namely the Sami origin of the goods in question. However, these marks cannot prevent industrially produced goods, let's say cultural look-alikes, which imitate the original Sami handicrafts from entering the markets. Still, trademarks could be applied also directly to individual traditional cultural expressions. Traditional symbols and signs can per se act as trademarks, and even different models of Sami dresses as whole could be protected by trademarks. This would allow a trademark holder to define the rules of use of, for example, Sami dress in commercial purposes. Trademarks as such are efficient and accessible form of protection. However, there are practical questions relating to this solution as well, and merely from a legal viewpoint, it is not possible to say whether, from political or social standpoint, the registrations would be recommendable. It must be asked, for example, if a certain Sami dress or symbol would be registered as a trademark, who would own it? Would it be Sami Council, Sami parliaments, a private company owned collectively by Sami parliaments? For the purposes of a registration, a mark must have a designated owner, and defining the owner might be difficult since Sami heritage is owned collectively and individually by each and every Sami person. Secondly, who could define the rules of use for the dress in commercial purposes? Would the license to use a dress in commercial purpose be different between a company fully owned by a Sami individuals or a company where Sami ownership is in minority or is entirely lacking it? Who should benefit economically from the use of a trademark such as Sami dress in commercial purposes, or how this benefit should be shared? There is also a risk that applying intellectual property rights directly to a cultural context disrupts the social and traditional dynamics within the communities. Could the trademark registration and perceiving a Sami dress as property influence to the views how the members of Sami community and individuals feel about it? So even on such a brief view, we can see that yes, already the existing intellectual property laws might provide some legal remedies against the misappropriation of traditional cultural expressions. The situation is not so bleak as it might firstly seem. However, it is of utmost importance to notice that the profound answer cannot be found merely on basis of legal analysis. Intellectual property rights in cultural contexts have also political and social implications, and therefore there should be a profound dialogue combining social and political knowledge with legal expertise. By this dialogue, it could be examined whether these intellectual property tools are applicable, efficient, accessible, and usable for the Sami communities. By applicability, I mean whether traditional cultural expressions meet the formal requirements of intellectual property laws. By efficiency, I mean whether the IP protection could prevent those problems that are relating to the misappropriations. For example, trademark laws do not prevent non-commercial use of the distinctive signs. By accessible, I mean whether the Sami communities have sufficient resources to manage and administer the IP portfolios, and can markets be supervised and these rights enforced. By usability, I mean if due to their nature as private property, IP rights can be shared and administered in complex social matrices of indigenous communities. In my mind, it would be worthwhile to establish a certain permanent body, an organ, be it an association, a company owned by Sami parliaments, a committee or such, which could accumulate all the knowledge and expertise on these complex matters, make legal, but also social and political analysis of the usage of these IP tools, and then make practical recommendations or suggestions for the Sami decision makers, which could then take determinate and concrete legal actions to establish the Sami presence as a community in the domain of intellectual property rights. Thank you everybody very much. Tack, kiitos.
Thank you very much, Tuomas. This was, I think, a good summary of one of the most important issues that is behind this seminar, is to try to look at the findings of this study and also other studies that have been made about Sami TK and IP in the Nordics. Next we have Anna Näkkäläjärvi Lensman. You have the floor, Anna.
Ollu kiihtu ja kiihtupouta jumis juokavit juurta kiihtan seminaari läkutnille mieltä. Suttuko ehpeässän kullat tammu musiikka outa märkka. Tahlei Pale Fails ja Ailu Valle musiikkapihta jostain paljon kauempaa. Ja tässä mai luhti mieltä. Ja nopeasti kultalämmentän tammu sahkavuorun manjeltasto kolla aiki. Vastatsettiinko kulla tämän musiikkapihta ja jurttasahti tällä hirma puures puhtautun populaara musiikkapihta ja tässä maittai saami artista ja saami kiellä mieltä millä hirmas soma ja toppe kulla maittai luhti ja ve sahtake jurttasit olla suvako saami voika huota imadus tan pihtas kään luhti tahleami toppe kullo lääkota olmoluhti vai elli vai paihki kiäsä luhti kulla. Jos tällä olmoluhti ja jos tällä takkar tolosluhti ja te olmossa jaatman jo, te kiidan manjel halttasa luodi, tahki voika huodai. Mun tiedän, ahte ailohasla joikan taas kerrui. Hei, rahkis, minä vaan puhumaan taas. Joo. Antakas siimusta tappe, on maita peruhtus mieltä. Mun tiedän, ahte tätä Lohtila valton ailohatsas kerros joikuja, millä rahkatuvun tuo hohtsuuri kuhtalogi kahtsi. Ja tietuske tasrajes, että saami immateriaala arppi suotjalämi lä outanan hui ollu. Ja that momi jurttosihtan pirra. Ja la illutan, ahte mital huppahta jashi pirra ja sahtihte outani taikkon. Ja sutjetan arppi. Human luodipirra, muhto jahkan, ahteta sama fenomeena lähkime koihtoke anaratsai liudekulttuuras. Ja nuortalatsai musiikkakulttuura saihta toima herralahkai, mutta monin tiedetas tan tarkilepput. Luohte arpe vierrulla ällikulttuura ja tatsehattala parrasemus laulun vuokki, millä ain ällime Euroopas. Tahlan jalmalas arpi, tas siirtasa polvas pulvi perratsi ja sokai mieltä. Sahtamaittai takiat ahte ta kulttuura lä aihtojuvon olle saami kuulus. Tanin ko tat moderna aiki ja moderna sisuuna vaihkuhan ollu min juokkapäiväsas ellimi ja arkapäivai. Saami kulttuura siste mi jurttasit ahte joikkalmas oomasta echas luodi. Nuupe tahki voika vuoda nai kulle suunje.
Thank you, Anna.
Mun jatkan vielä. Yes. Saami Pokala musiikka arpevierolla purkejuvon tuo hohtisuodi loku alkkurajes. Arkivaide, sihke kirjalla tjahotte pattiide. Suomaske kaunoit arkiivan mankkahtsuodit, liude, leut ja luodipattit. Maittai Eurooppa museain ja universiteettain kaunoit luohtepattit. Täällä tieduskeli tehallas kaltu, säilyhi ja elaskahti luohte arpevieru. Saami-perspektiivas, kun kähtsä arkivait ja suomas vaattisvuotan lää, ahte iilä lähkimme tiehto vuodu, mi sistoalla oli tiedui taas, mi arkivaidella vurkkojuvan. Ja arkivaistoalut hävsäivänsä, Fertelä nanu saami kulttuura toutamus, ahte ihminen jopa vähäs maita arkivas ies alte sistollet. Nuppi taavus pallun lää ahte pares paatti, odjo vetsä arkivain kähpeäre. Samma laatiko kakti, luohti, kulla, tusse saamiive. Ieskudehke arkivas läht ieskudehke njolkkaadusat käspeesse patti kultali ja keavahit. In tiedä makkar lahka patti suotsela vai suotselako makkarke. Saami artista koihtokke keavahit arkivapattit ollu. Ja parke huike sunnait. Ja maittai keavahi pares pattit. Sisteloppe musiikkas. Napadan aikeluodit. Mitki lähtän vurkema kolle aikkimanjen riekatan hui ollu odda luodit. Mun aina nähte taihkelitsi tarpuu systemaattalatset vurke ja tjakkit. Musiikka suorkki tahkii voikka vuotta servinnuuko suomas teostos lääkkeä vahas parku. Tahlas soapahedjit. Musiikka tahki ja musiikka kävähetsi ja musiikka tahki kaskas. Nuppin saani kuin teosta pakte musiikka tahki adju puhtautusa iätsäs musiikka kävähämis. Ja teosto toutaa komponista, toutaa saani challi, heivejätsi ja nuviita seopot. Muhto, tahi toutta joikkalmasa ja tahi ihmir ahte luodit ja toloske luudit ja toloskeluudit oamastit kollektiivalla saami sokat. Tahkii voika vuotta laahka toutta saami rekteprinsipait ja tahtaka haastalu sai artisti ki haalita parka musiikkaan ja kunnejahti saami rekteprinsipait ja arpevieru. Jos tahkii voika vuotta laahka kautna joutosi heidehi ahte torju saami artistai ja saami almoka outanemi tahjesatte sahtalle mieltä jaukkademen arpevieru. Mo, teosto, Kramex ja ERA musiikkaorganisationer mah torjos suoma musiikkaindustria, torjos saami musiikka ja artistait. Mi tarppasi torjaka, mi touttasta min kulttuura toimavuukit. Mi tarppasi tal raafi parkui, kosmi säilyhi ja ealaskahtit, luohte arpevieru, liude arpevieru ja leut arpevieru. Tanilla eranomas tehalos ahte mi sutjet maittai saami vakala musiikka arpevieruit. Posto keavahemis. Ja ahte min iätsämet voika vuotta ihmadus pessa olla suvat. Ollu kiihtumu välis.
Thank you very much, Anna. I wanted to just raise your attention to the slide that we have in front of us and the sound clip. There is the information, the metadata on who are the right holders, that they show the word, the names of the songwriters and also traditional. And this will probably the link with the Sami Joik, and whether or not it's considered to be traditional in that particular sense, we will find out about it now when we get an English translation of Anna's speech. Thank you very much, Anna, once again. Now we give the floor to Jerker Rydén, who will present the project of a virtual digital library in Sweden. So please, Jerker, you have the floor.
Well, thank you very much. It's a project idea. I stress that it's an idea, a possible area of cooperation between cultural heritage institutions, the Sami community, the Sami Council, and other relevant bodies. Well, cross-border access to Sami culture heritage, a virtual Sami library. Is that a realistic possibility? The cross-border aspect, I think, is quite natural with the Sami culture heritage because it is cross-border by nature. and therefore that should be the default. Digital repatriation of the Sami culture heritage is also a way to look at this. And since there are many legal aspects, one could ask oneself, are they obstacles or possibilities? Usually people tend to address the law as an obstacle. But we all live under the law, and that's part of the sort of the democracy and the rule of law. But with the Sami culture and indigenous people issues, this has a very different sort of twist to it, which been addressed previously. We have sort of a friction, and these slides is regarding how to find a way to find a way forward. The Sami culture is embedded in documents that can be found in cultural heritage institutions in Norway, Sweden, and Finland. And it's the kind of material that I addressed in my slides, not Sami culture in general, but the culture that is embedded in these documents. And cross-border access to this cultural heritage embedded in these documents require a cooperation across the borders, as I see it, between the institutions that have these documents in their archives and the Sami community, the Sami councils. These material include the intellectual cultural heritage created by and belongs to the Sami community, and information about the Samis. And it is, as well, as I mentioned, to a very great extent protected by copyright. And also one other aspect is, which is not addressed in the conference but should mention, is integrity law and data protection. Usually you refer to GDPR. Digital repatriation requires the consent of the Sami community and the Sami community's rights to be respected. That's an obvious starting point. And then you also have copyright itself. As to the cross-border access and provide cross-border access, Sweden and the Royal Library has some years ago, in cooperation with Finland, provided cross-border access to audiovisual works. It was broadcast in our collection from the 60s, 60 to 69, Sveriges Television, to test if cross-border access could be made possible using what's called extended collective licensing. It's actually a collective license based on mandate from the rights holders, and by law, the license is extended to the non-mandate right holders that have not provided a mandate. And the pilot was very successful. We was able to provide cross-border access, and it was very much appreciated in the copyright community as a possible way forward to cross-border access. This could then be a way forward, a possibility to use the law in a creative way, and this context of providing cross-border access to the Sami culture embedded in cultural heritage institutions documents. As to the virtual Sami library, is it an illusion or is it a partial vision? I would say it is very much a vision. If we share it, we could achieve. It's not without any realism. It is something we could pursue. But there are uncertainties as far as the law, and I think there's a regard to this. There's a need to at least an informal network that could address these legal issues by attorneys and provide possibly recommendations on how to overcome these obstacles or pursue legal possibilities. So the idea I have sort of present is to firstly then look into these legal issues, which are requirement for digital repatriation, and implement the Sami's right and capacity to control the access to their cultural heritage in these documents. And lastly, to actually launch real live cross-border pilot providing cross-border access to the Sami cultural heritage. One could have different sort of audiences, one could elaborate on researchers or etc. And I would like to stress also that this project would not be normative, requiring new legislation. It would be, as far as copyright is concerned, suggestions on best practices, and as far as data protection in the framework of the existing EU regulation, codes of conduct, which is an interesting topic itself, but this is not the forum to discuss this. By that, thank you very much for the possibility to speak about these issues, address them, and if you have any questions, you have my email address, and you could email me, and we could continue the dialogue if you so wish. And thank you very much for me, and I look forward to the rest of the day.
Thank you very much, Jerker, for your slides and your presentation. I think this is sounds a very interesting project. I hope that we are able to discuss that later on and go into detail. I think one of the purposes of this seminar is to get glimpses of interesting ideas here and there and continue discussing with new colleagues and with old colleagues as well, and to try to cooperate better on the Nordic level.